General Masemola is charged with were dead, all of them. And therefore, there was no question of them being charged with all the offenses, with any of the offenses you are seeking to rely on, and to suggest that General Masemola's charges are additional to. So General Masemola then has to be charged under the PFMA all by himself. So what would the PFMA charges be additional to? What would the PFMA charges be additional to? Nothing. You get my point?
Yes.
So it's on that basis that I say your attempt to just force the PFMA charges being additional simply does not work. Do you agree? It doesn't. It doesn't. Because all that General Masemola is charged with are the PFMA offenses. So when you look at him, those offenses, insofar as General Masemola is concerned, are not additional to anything, are not related to anything. It's just those PFMA offenses only. And you cannot force the additional by merely relating to charges faced by other people, charges that have nothing to do with him whatsoever. And the cruel example I give actually makes the point abundantly clear. Do you agree?
I agree, it makes the point clear.
Yes.
If you'd allow me to, and then I stop.
Yes, yes.
In the manner in which it transpires, the PFMA is in relation.
Good morning, Mr. Bodani.
Good morning.
Good morning, Advocate Johnson.
Good morning, Chair.
Let's start here. You remember yesterday we gave you some homework that stemmed from a question put to you by Commissioner Baloyi. And that question concerned the 4 counts that General Masemola is charged with. All of which are based on the Public Finance Management Act, or the PFMA as it is usually called. Commissioner Baloyi's point was, Commissioner Baloyi suggested to you, and she wanted a response, that those charges cannot stand alone. They must be related to some other offenses that do fall under the mandate of IDAC. You remember the question. I added to that question the fact that the section actually makes reference to additional. And I said to you that surely this must mean that the offenses under paragraph C of section 7, 1, capital letter A, those offenses under the specified statutes there must therefore be, because of the use of additional, be additional to something that's already referred to. And if it's only offenses under the statutes, then IDAC does not have a mandate. I even said to you, you must give meaning to the word additional. In fact, I should actually have gone further than just additional. I should have said this is additional related, so underline related as well, statutory offenses. So you would have to give meaning to additional related statutory offenses. And if what General Masemola is charged with are only the statutory offenses, in fact, in this case, statutory offenses relating to only the one statute, the PFMA, on what basis does IDAC have a mandate to charge General Masemola under the PFMA, standing all by itself? unless you have a different, or you give the words additional related statutory offenses a different meaning to the one I'm suggesting to you. Can you please respond?
Good morning, Chair and Commissioners.
Yes, good morning. Good morning, Advocate.
I've done the homework. I don't know if I'm going to pass, so we're going to give it the best shot that I could. I did go back, and it is correct, Commissioner Baloy, that he faces charges relating to the PFMA. And so we've got to go back into Section 7, especially 7(1)A, and say, in the absence of. Now, we have several accused that are charged. And you will find that not all of the accused are charged for all of the same offenses. You may find that some face 3 or 4 and some face just 1, etc. But they all arise out of the serious, complex corruption and commercial crime matter, which is the Medicare matter. It is in that vein that we go back, Chair. And when we look at Section 7(1)A, the sub-A, our case, the Medicare matter, relates to serious, high-profile, or complex corruption, commercial or financial crime cases. That is the umbrella of the cases. The involvement of Commissioner Masemola in relation to the serious, high-profile or complex corruption, commercial or financial crimes are as related to the PFMA. When these offenses were allegedly taking place, the serious, complex, commercial, General Matlow, from the risk audit of the police, brought it to the attention of the then commissioner to say that there is these offenses taking place. There's unlawfulness happening in this contract. And Commissioner, as the accounting officer, you need to stop the contract and therefore it would therefore stop the payment. It took him a long time to do so. And what then happened is, in not acting in terms of his duties as the accounting officer, to act promptly, to act diligently, monies were in fact then paid out because of these unlawful corrupt activities in the approximate value of 50 million rands. And then the contract was stopped. We said it is all flowing out of the main transaction. It was brought to his attention, and the bringing it to his attention is because he is the accounting officer. And had he acted, then the perpetuation of this unlawful corruption, commercial and financial crimes would not have taken place. It is so, Chair, we never said that he was party to the corruption, but he is being charged then for the PFMA arising out of those matters that he had become aware of, and that we say he then did not stop. And that is as...
That's a valiant attempt, but I do not think it takes you to a pass mark. Let me make a very cruel example and say, let us say all of the people. You see, for as long as you agree with me and you are not able to argue against my cruel example, that point simply does not work. It doesn't. Because if he was all by himself, it would be nonsensical to talk about additional, because it would be additional to what? Additional to what? Because that additional is a conscious choice of word by the legislature or the legislator. It's a conscious choice of word. Otherwise, they would just have said relating to these statutory, or rather, offenses arising from these statutes, and then the statutes would be itemized. The use of additional is because there must first be other offenses. Otherwise, additional simply does not make sense. You must accept that.
I leave it there, Chair.
Do you agree that otherwise...
I have to agree with your reasoning.
Sorry.
I have to agree with your reasoning.
Thank you.
I made the point.
Does not. Thank you.
Advocate Silo, there's a further issue on this. If you go to file 9 on page 3520, this is General Matlo's own affidavit.
Sorry, Advocate Johnson, you should not leave your seat when your testimony is concluded, being under the belief that the commissioners are suggesting that General Masemola has no case to answer insofar as the PFMA is concerned. We are not suggesting that at all. What we are focusing on is IDAC's mandate. IDAC, insofar as the PFMA is concerned, on our reading, IDAC's mandate is only if there are other charges and then the PFMA charges are additional to that. That's all that we are saying at this stage. It's about IDAC's mandate.
I hear you.
You see what I mean?
I understand.
So whether or not PMA offenses have in fact been committed is something else altogether, but it's not something that must be pursued by IDAC. That's all we are suggesting to you.
Thank you, Chair.
Thank you.
That is how I understand it.
Do you accept that, like any of us, when you get opinion, you first have to consider it, you first have to apply your mind to it before you act? Because if you act in haste, you could be sued for breach of contract, you could be sued for failure to apply your mind. I mean, some of the issues we've criticized you for was blindly accepting briefings without looking at underlying documents to satisfy yourself that, the Section 27 read with the Section 28 applications are actually consistent and they are relevant to the complaint of Mr. Adams. So one does not, in the normal course, you get advice today, you act immediately. In the normal course, you would apply your mind to that advice and you would ask questions if there's a need to ask questions. Because I don't see anywhere in General Matlo's affidavit where she says it took the National Commissioner 6 months after he was given the advice to act on it. Because that paragraph 9 says, I gave the National Commissioner advice and then he terminated the contract. So there's no suggestion by, if General Matlo is the complainant, there's no suggestion by General Matlo that General Masemola did nothing with my advice or he took inordinately long before acting on that advice. And as a result of his failure to act on the advice, there was the loss. How I read this affidavit, it says the 50 million is what was paid throughout, not after the advice was given. But the charge sheet creates the impression that the loss happened after the advice was given. Morning, Advocate Johnson.
Morning.
I'm going to deal with process leading to the charges by IDAC. So the Section 27 affidavit or
Sorry,
additional...
Chair. I think sorry, Commissioner Khumalo. I don't know if the Chair found...
In response to Chair, you referred to General Matlo's affidavit. So if you look at General Matlo's affidavit starting on 3519, what she says in 3520 in relation to General Masemola is that, so first of all, she's the head of risk and integrity, so head of risk and compliance at SEPS. And she would have investigated these issues, as I'm sure her job description requires her to. And then she says in paragraph 8 on 3520, she then advised General Masemola to consider terminating the contract with Medicare to save subs from irreparable harm and to diminish the financial prejudice suffered by subs. Then she says General Masemola terminated. So General Masemola accepted the advice. Do you see that?
Yes.
Now, if you read section 86 of PFMA with section 38, what it requires is willful and grossly negligent conduct on the part of General Masemola. As I understand those two sections, they would kick in if, notwithstanding the advice by the head of risk and compliance, he does absolutely nothing. Because then that would be willful and grossly negligent. But if your head of risk says, I've investigated this, here is an audit report that shows that at the time when you did not know, some members of SAPS in supply chain were colluding with Mr. Matlala's company. And as a result, this contract was concluded. They were also colluding in relation to the issue of, I think it's in charge 3, of the orders, of the purchase orders, which is not something that as a commissioner you would generally know because it happens at supply chain level. If now head of risk investigates, gives you an audit report and says, the purchase order process and even the granting of the contract from the beginning were tainted by criminality. You as accounting officer, you come in at that level and you say, now that I have all this information, what do I do with it? And if upon receiving that advice, you terminate the contract, where is the willful, intentional conduct and the grossly negligent? Because the way these charges are formulated, IDAC is basically saying from the date the tender was awarded, because they say from May 2024 until May 2025. So they say from the date the tender was awarded, already there was willfulness and grossly negligent conduct on the part of General Masemola. But that cannot be if you look at the issue of the purchase orders, for example, in count 2. Those only started coming in after the tender was awarded. And payments only happened after services were rendered. So it cannot be that from the 8th of May already, because there was no tender on the 8th of May. The service provider was appointed in June, and after they were appointed, we've had evidence that there were then meetings about how the contract is going to be implemented. And the contract was then implemented much later, from September onwards, if I remember Brigadier Macheng's evidence correctly. So it's not clear to me how in May, June, July, August, PFMA breaches could have occurred on the part of General Masemola. So do you see where I'm going? That you can only sustain the PFMA charges, the ones that are formulated at least. There may well be others that he's guilty of and we are not aware of. But the ones that you have in count 1 to count 4, you can only sustain them if after he has received advice from the head of risk, he ignores that advice and allows subs to continue with this contract. I know I've said a lot, so maybe respond only to
Commissioner, that I asked if there was only the 27 at the time when they had this matter. I'm given to understand that General Matlo submitted a preliminary report together with the Section 27 affidavit. I'm not sure if it is before the commission, but that must be something that that would then have to be asked, as it might just give a different context, but I'm not seeking to take the point further in terms of the conversation, Commissioner Khumalo, between you and I.
But looking at only paragraph 8, do you accept that the General says, I gave advice to the National Commissioner, the National Commissioner acted on the advice? The affidavit does not say the National Commissioner failed to act or did nothing with the advice given to him.
I understand that.
Yeah.
On this issue, my concern in the debate about whether or not this falls within the IDAC mandate is that on the charge sheet itself, there is no allegation of corruption. You don't make that allegation in the charge sheet. The charge sheet and the charges are purely statutory contravention, PFMA, and working off the charge sheet as it is now, the impression that it creates, or that in my mind has formulated, is that there was no good faith intention to prefer a charge because it is justified, it is supported by the facts. This was just a scheme to get him arrested or present to court, to have him appear in court, and the purpose is achieved just by that fact alone. So you don't even get to the validity of the charges. Yeah, that's why we don't discuss with you whether there's merit in the charges themselves. That's for the court to determine eventually if it does. But that which is obviously, at least in my view, which is obvious from the charge sheet and must have been obvious to the lawyers in your office and to the prosecutor who approves those charges, it must have been obvious just on the charges that we are not making an allegation of corruption against him. How do we justify him being here? That must have been obvious. And accepting, because it's difficult not to accept that it was that obvious to the lawyers who dealt with this. Accepting that it would have been obvious to them that this charge sheet is wholly inadequate for purposes of our mandate. There has to be another reason why, anyway, you approved the charge. If you did do a prosecution memo, you were prepared to do the prosecution memo and say to the prosecutor, I think you said it's a DPP, and for the DPP to approve this charge as it stands without saying to you, hang on, go back, include corruption in there so that it falls within our mandate. To me, it gives the impression that the whole purpose of this charge sheet was to just have him appear in court. Just have him, let's create a paper that presents him to court and he becomes an accused with a consequence that we now publicly know happened, which is he was removed from his position, whether it's a leave or suspension, whatever, but he's not in office. And I say that, and forgive me if I'm repeating myself, I say that because it's inconceivable to me that a whole lot of lawyers who looked at this charge sheet, none of them said, hang on, we can't do this. This is not good enough for purposes of our mandate. If we want to charge him as involved in corruption, even your interpretation that you give to the chair this morning, if that interpretation had been discussed, it would find reflection in the charge sheet. However, inelegantly expressed, if the idea was that, well, you know, he's implicated in the corruption, even if it's just these sections, but that connection, it would have found expression here with a lawyer's eye. And that it doesn't find expression suggests to me is because you couldn't do it. None of you could get to the point where an allegation of corruption is made or him is being linked to the other accused conduct. And for that, you couldn't go that far, but it didn't matter because the real intention was never to get a successful prosecution of corruption or a successful prosecution that comes under PRECA. That was never the real intention. In my view, the intention was, as I say, get him arrested with the spectacle that comes with it, get him charged with the consequence that naturally will follow, which is the minister and hopefully even he, National Commissioner, would say it's untenable for me to remain in this position while I'm undergoing a criminal trial, and that was its only purpose. That's what it looks like to me. You may comment if you want.
About the same place, same time as the Commission of the Fraud and Corruption? Not by any stretch of imagination, I do not think.
Correct, Chair.
So General Masemola was wrongly lumped with these other people. You must accept. You accept that?
I see that.
You certainly must. Now, even when you look at jurisprudential precedent, I will refer you to, I know you're a good prosecutor. I watched you arguing, which appeal was it? The Pistorius appeal. You are actually a good advocate, I think, on my assessment. I will refer you to jurisprudential precedent with regard to the court's exercise of discretion under section 1, under one of the sections I've just referred to. It should, I think, be relevant more to 156. Let me just see if the case was dealing with 156. Anyway, let me not waste time. Let me just read you what Trolip J.A. held. He says, in exercising its discretion, the trial court has to weigh up the likelihood of prejudice to the applicant accused. That is, the applicant accused would be the one saying, please, please, let my case be separated from the cases of these other accused. So the applicant accused, resulting from a joint trial against the likelihood of prejudice to the other accused or the state if their trials are separated, and decide whether or not, in the interest of justice, a separation of trials should be granted. Prejudice there means prejudice in the sense that no injustice should be caused to the party concerned, including the state. If we look at this, but what's crucial is that you've already accepted that in any event, General Masemola ought not to have been lumped together with these accused persons that are charged with fraud and corruption. Bear in mind that yesterday you accepted already that General Masemola is not complicit in fraud and corruption. Now you accepted now in my engagement with you now that he ought not to have been lumped together with these people. Now that he has been, surely, and based on this principle, you must also accept that he would suffer the sort of prejudice that Trolip J.A. says an accused person should not be subjected to. And I cannot see any countervailing arguments to the effect that the state will suffer any prejudice if he is not lumped with these other accused persons. Do you agree with me?
And if, I think when it was flighted,
these PFMA charges, perhaps let me take you to a different but related issue. Ms. Sillo, please.
Yes, Chair.
Let me do so, Advocate Johnson. 1 I'm sure you know what sections 155 and 156 of the Criminal Procedure Act provide with regard to joining accused persons in the same set of criminal proceedings. Perhaps for the record and those viewing these, for their benefit, those viewing these proceedings, let me read both sections. 155.
Chair,
yes.
Apologies, we are trying to project, so perhaps when you read, it will be projected as well. Thank you.
All right. Section
157.
155 and 156.
155
and 156, so Criminal Procedure Act. Yeah.
Coming up. Thank you.
155 is headed, persons implicated in same offense may be tried together. So I would say, please underline even that heading itself. Of course, our law and interpretation says a heading may be a guide, but is by no means determinative. But I will say, let's underline it. Then the subsection 1 reads, any number of participants, and I emphasize what follows, in the same offense, so you underline same offense, may be tried together, and any number of accessories after, again underline, the same fact may be tried together, or any number of participants, again underline, in the same offense, and any number of accessories after that fact may be tried together, and each such participant and each such accessory may be charged at such trial with the relevant substantive offense alleged against, I will say, them. Surely, in charging General Masemola together with people charged with fraud and corruption, you did not rely on section 155 subsection 1. I must be correct in that view.
That must be correct.
That's correct. Okay, let's go to, I don't think subsection 2 is relevant, so let's skip to section 156, which is headed, persons committing separate offenses at same time and place may be tried together. That too is quite crucial because I'm interested in it. If we look at what Commissioner Masemola is charged with, one immediately wonders if it can be said that he committed offenses at the same time and place with the people that he has been lumped with. But again, I will make the point I made earlier that a heading is merely of assistance and not necessarily determinative of the interpretation to be given to a statutory provision. Okay, let's go to the provision itself. Any number of persons charged in respect of separate offenses committed at the same place and at the same time. Underline that. Now it's in the substantive part of the provision, so no longer just the heading. And or at about the same time. So that too, at about the same time, may be charged and tried together in respect of such offenses. And then here's another crucial part. If the prosecutor informs the court that evidence admissible at the trial of one such person will, in his opinion, also be admissible as evidence at the trial of any other such person or such persons. Do you think this subsection applies? Or rather, this section, it has no subsection. Section 156, do you think it applies? In what way has General Masemola, based on the PFMA charges, committed those PFMA charges at the same place and at the same time as the commission of the fraud and corruption. Surely that cannot be suggested, I do not think. Can you just respond to
Yes.
what I suggested
Yes.
to you now?
And I wanted to say that
Yes.
because of, if you read 157,
Yes.
that becomes a bit more, is more appropriate
Yes,
than in the
yes.
circumstances and given the jurisprudence.
Yes. But you basically agree with me. You've already agreed that he ought not to have been lumped together. Then I'm making another point, although related, which is that he will definitely be prejudiced in a trial that lumps him together with these other accused who are charged with fraud and corruption, both of which he is not charged with. Do you accept that?
I accept that.
Now, a question that goes to what I've always emphasized, I think I did so even on the first day, which is that we are not trying to suggest that General Masemola has committed no offenses, no. But, and this is something that Commissioner Baloyi's question touched on, we want to know why this was done. Why was this? You've agreed very easily. You know these principles. You apply these sections all the time. Why was this done? Why was Commissioner Masemola lumped with these people, charged with fraud and corruption when he is not? When he is charged with the statutory offenses provided for in the PFMA, why was he lumped with these people? At face value, it seems to me that this must have been done to embarrass him, to taint him, and to make the public, or to cause the public to see him as also being complicit in fraud and corruption. People are not going to, ordinary members of the public are not going to analyze this. He stands there. People charged with corruption, fraud, he stands there with them. And most of the noise when the case is talked about, it is going to be about the fraud and corruption. People are not going to delineate and say, but not Masemola. Do you see what I mean? So this was done, I suggest to you, to embarrass him, to taint him, and to make him look as if he too has committed fraud and corruption. That was calculated, I suggest to you. What do you say?
Chair, I gave the contention that I did, that the prosecutors put him in one matter because there's the serious complex fraud corruption, and it would be one matter when they lead the evidence with the PFMA. I'm giving you the explanation that I have for the prosecution. I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masemola was there an intention that he be embarrassed.
Were you involved with the decision to join him as a co-accused in this, with the other accused? Were you involved with that decision?
Yes, the prosecutors take the decision. When we were briefed, we agreed that he's charged only for the PFMA.
No, my question is, someone made the decision that he will be accused number, whatever number, on that gallery, right?
The prosecutors.
My question is, before that decision, or when that decision was made, were you party to that decision when it was made?
That he would be added at the end.
That he's added as a co-accused with the other, however number, whatever number they are.
Based on the contentions that I've given, which was given at the time, yes, ma'am.
You see, what's problematic with this is the fact that you have already agreed that in terms of the sections, he ought not to have been been joined at all. He ought not to have been. Now, what makes this situation worse is the fact that he is being joined down the line. Not that it would have been correct if he had been joined at the same time the charges were brought. No, that would still have been legally wrong in terms of 155 and 156, and you've agreed to that. Now, but what makes it worse here, he is joined down the line. Surely your minds should have focused on, we already have charges against all of these people. We are charging them with fraud and corruption. Now we want to put in an additional person. Is it in accordance with the law to join him in terms of 155 and 156? Surely your mind should have been focused on that. It's not as if a mistake happened. We just lumped these people together instantaneously. It sort of just happened. But anyway, I say, things like these cannot just happen. So if it's wrong in law, it would have been wrong, even if he was lumped right at the beginning. But now, the point I'm making is, you lump those together, they are all charged with fraud and corruption. It makes sense to lump them together in terms of 155 and 156. Now with him down the line, how is it that your minds are not specifically or particularly focused on, but must we lump him together with them? Surely your minds should have been so focused. Otherwise, I do not understand why that was not the case.
I understand you, Chair.
Did you? I may be repeating Commissioner Baloyi's question, but I will repeat it for emphasis. Did you focus your own mind on this issue at all?
Yes, there was a discussion on whether he was going to be charged separately or whether he was going to be joined. I give the argument and can take it no further than what was given.
After that discussion, or during that discussion, did you specifically focus on which basis under 155 or 156 we can join him? Did you focus your minds on that?
Not me specifically.
When you said there was a discussion, did that discussion not involve you?
The discussion involved with 157. Should he be charged separately or should he be judged jointly? The prosecution
you can't, sorry. You can't separate 157. It must relate to 155 and 156 as well. You cannot separate 155 because you charge people in the same proceedings if they have committed the same offense.
That discussion happens and then we go to we then go to Commissioner Masemola.
So you were part of that discussion, you say?
With the prosecutors. Yes, when they did the briefing. Yes, there was an engagement with the prosecutors.
Yes. And you concluded that there was a legal basis in terms of the Criminal Procedure Act to join him in these proceedings. And if you say so, and you must have reached that decision. So if you say you found a legal basis, what was that legal basis? And in terms of which section exactly?
So in terms of the legal...
Let's stay with the Major General Matlo's referral affidavit. And that's file 9, page 3519. And based on our engagement yesterday with the commissioners on matters relating to General Masemola's arrest, this is our starting point, correct? General Matlo's affidavit is what eventually triggered the arrest, the eventual arrest and prosecution of General Masemola.
On a point of correction, I did indicate earlier that she submitted the section 27
yes,
together with a preliminary report.
which preliminary report has not been provided to us. And I want to see how you reach that conclusion when on the wording, the very wording of the affidavit, there is no suggestion that anything is attached thereto.
I checked with the team, this 27. Did it have anything else? Because that is the question. In the absence of anything else, council, which was the conversations we were having yesterday,
yes,
then a lot of things could not have happened. And I was informed that there was a preliminary report that was attached.
It doesn't particularly help the commission because only you and whoever it is you spoke to know of an existence of some preliminary report. The document that triggers this entire process does not even suggest it's submitting any further documentation, preliminary or otherwise. If you go to paragraph 5 of that affidavit, it speaks of a comprehensive internal report is currently being compiled. It doesn't say in the interim here is a preliminary report. So on a logical interpretation of paragraph 5 is that an internal audit process was underway. The fact that she describes it, the outcome thereof as a comprehensive report does not detract from the fact that it is underway. Do you agree with me?
I understand.
So I look at the rest of the affidavit and there is nothing that suggests that even she, as component head risk and integrity management, had formed a view on the matter, however preliminary it is. Do you agree with me? At least based on the document itself. Do you agree with me?
I agree with you.
Yeah. Now, if we look at her paragraph 3, she says she wants you to investigate.
Sorry, paragraph 3.
Paragraph 3, yes, of General Masemola affidavit. She wants you to investigate IDAC, that's who I mean. The alleged unlawful awarding of a tender to Medicare 24, Tshwane district. You see that?
Yes.
Now, the charge sheet that came out of this entire investigation process invokes section 38 of the PFMA, solely section 38. And you know that if we take a step back, section 217 of the Constitution prescribes that all organs of state should establish a system and make appointments regarding bid adjudication, bid evaluation, and that entire formal structure to deal with the issues of public procurement. So the awarding would have been done by, the recommendation would have been done by that procurement system. It then lands somewhere where the decision maker has to determine whether they accept the recommendation and they reject the recommendation. Is that your understanding of how public procurement works?
Yes.
And in deciding to reject, administrative law tells us that that decision maker must set out the reasons which must be reasonable and rational, because the responsibility and duty to manage matters of procurement lies elsewhere in the organization. Do you agree with that? Are you with me thus far?
I'm with you.
Now, with that understanding, if I go to the charge sheet and I look at charge 3, how do we rationally explain away charge 3, which is a charge of gross negligence for failure to comply, in that General Masemola, him, I take it as the accounting officer of SAPS, failed to ensure that Medicare 24 Tshwane district was properly screened and tax compliant? Whose duty is that?
That must be the bid evaluation.
So why, and now I'm just trying to get some, why is he being charged for failings of by the bid evaluation committee, if we have since discovered that in the process of evaluation, it turned out that this particular entity was not tax compliant and neither was it properly screened. Unless we are suggesting the bid evaluation committee and the bid adjudication committee, after they have discharged their duties, the whole tender and process and documentation must go before General Masemola, where he must satisfy himself that this entity was tax compliant. Is that what we're suggesting? Amongst others.
Doesn't make sense.
I didn't think it would. Staying.
It was the argument was used as the at the bottom of 156 of them being charged together, because the evidence at the trial of the one would be used and may be admissible at the trial of the other person.
Is evidence about the commission of corruption, the commission of fraud, admissible as against General Masemola? If so, for what purpose?
Not admissible against him, but to lead that evidence to then show it. Continue. Please continue. Okay. It was in having this one trial, you lead the evidence of the fraud, the corruption, all of those irregularities. And it's all the same evidence that will then talk to the PFMA evidence, because you would have to lead, if you take him and put him separately, you would still have to lead that same evidence to get to him, to show what was the irregularities and or the unlawfulness that was happening, who all was involved, and what were his duties. So instead of duplicating that evidence, they put them all in one matter. We would lead that evidence. It will then in turn show that serious complex corruption, etc., that happened, had it been stopped when it should have been stopped, would not have led to this. Not doing it together, Chair, as was argued, would mean we'd have to do two separate matters. That was the discussion at the time.
Was that correct? Insofar as he is concerned. Remember, you just said, in response to my last question, you just said, evidence of the commission of corruption and the commission of fraud is not admissible as against General Masemola. And if you look at 156, that is what a prosecutor must tell the court as to why the prosecutor is joining the accused persons together. So if you accept, as you did in response to my last question, that evidence of fraud and corruption is not admissible as against General Masemola, you do not get off the starting blocks under 156. Do you agree?
I agree.
So
I was giving you the discussions that we had,
which were wrong ultimately in terms of the decision that was reached. Do you accept?
I'll accept it.
Thank you.
Johnson, that precisely makes the point, because Section 38(1)(e), as Commissioner Baloyi correctly points out, is in relation to substance tax compliance. Yet the reading of that charge suggests that Tshwane, is it Medi 24, ought to have complied with that particular section, and that General Masemola failed to ensure that Tshwane complies with that section. You see the challenge?
Yes.
And the interesting thing is the entire charge sheet is based on Section 38, and I'm just going to quickly project Section 38, because I think this is what leads to the challenges, for instance, in count 3. Section 38 of the PFMA prescribes that the accounting officer for a department, trading entity, or constitutional institution, Sub A, must ensure that the department trading entity or constitutional institution has and maintains, and I will go to Roman 3, an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost-effective. On a reading of that, you would agree with me that that is the responsibility that General Masemola bears. He must ensure SAPS maintains an appropriate procurement and provisioning system that is consistent and compliant with Section 217 of the Constitution. Now, it is that system that receives, interrogates, bids. My logic, which may very well be faulty, would be his failing to the extent that it falls within 38. The charge ought to have been, my view, that he failed to comply with 38(1)(a) Roman 3. He did not ensure SAPS has got such a system. Would you agree with that?
I agree with that.
Now, if we go back to charge 2, and charge 2, I will read with General Mato's referral affidavit at paragraph 3, just to remind you, at 3519, General Mato had indicated that she was initiating a criminal investigation into the unlawful awarding of a tender to Medicare. And if one has regard to 6, we learned that 7, we learned that Medicare 24 was awarded that tender and resulting in a contract being concluded. And at 8, we learned that General Masemola terminated that contract. Firstly, if then we follow the logic of procurement of a bid process, it culminates in a contract, and as General Matoi points out, that contract brings into being contractual rights and contractual responsibilities and liabilities. So I suggest that once a contract has been concluded, which on the face of it brings about the rights and liabilities, that contract must be set aside, lawfully set aside. Do you agree with me?
Yes.
And in fact, it would appear that becoming persuaded, he actually chose to cancel the contract. And I don't know if you are aware that Mr. Matala attempted to go to court, or there was discussion between him and other members of SAPS to challenge what he termed the unlawful termination of the contract. Now, I go back to the affidavit, armed with the knowledge that we have in the affidavit, knowing what he did, appreciating the legal parameters of what he could do and not do. How do we even get to investigation stage? At which point do you say, as the accounting officer yourself, if you're accounting officer of IDAC, the head of IDAC, at which point do you say this is a non-starter insofar as Masemola is concerned? Remember, I rejected the notion that there was a preliminary report, and I rejected on the basis that this very affidavit doesn't even suggest one was tendered. How? I still have a struggle with how this even saw the day of light insofar as Masemola is concerned. And I was hoping that perhaps you might shed light and draw attention to some document that perhaps we may have overlooked.
I can't take you any further other than if they had presented the preliminary report, it might have given us a different perspective. Not having it means I have nothing to give you.
Yes. Now, it's a pity the system is a bit slow. You recall yesterday I suggested to you that internal audit report that General Mato references at paragraph 5, as I understand things, it's what gave General Masemola the basis to terminate. You don't have to agree with me. It's what I have learned in the course of investigations. So when it does come before us, its date would precede the date of termination by General Masemola. So he acted upon the advice of internal audit, seemingly. Would you have difficulty with that proposition?
I have to take your word for it because I have not seen it and I don't know it.
Yes.
And I don't believe you'll put a proposition that later on you can't back up. So
No.
I accept it, Council.
Thank you for the confidence.
The same point you made with paragraph D of section 38, with paragraph
Yes.
E, applies with regard to count 2 and paragraph D.
Indeed.
Because if you look at F says he must settle all contractual obligations and pay all monies owing. So for as long as the contract was alive, he had an obligation to pay Medicare 24. D deals with something completely different. So breach of D is not consistent with count 2. Because count 2 is about it's about maintenance and management of assets. So make sure that assets don't get lost. Make sure that if you have liabilities, they are managed. But the charge says he shouldn't have paid invoices. He shouldn't have accepted orders. Now, if he did as the charge suggests, he would have breached F of section 38(1).
Indeed, Commissioner, and to assist you, Advocate Johnson is projected the subsections D and F. We've spoken about E, D, F, and D is relevant to count 2. It is on the screen, and that is what Commissioner Khumalo is referring to.
So under F, Advocate Johnson, for as long as the contract was alive, subs had an obligation to accept purchase orders and to pay invoices. But the charge suggests that General Masemola should have acted contrary to 38(1)F and not paid the invoices and not have accepted the purchase orders.
I see.
Do you see the problem there?
Thank you, Commissioner. And then staying with the issue of the internal audit report, which you accept, my proposal that it is on the basis of that internal audit finding that General Masemola terminated the contract. And the proposition to you was if he terminated on the 15th of May, that audit report was availed to him prior to the 15th of May. You do accept, you said you accept, at least for the moment, because you haven't seen General Mkwanazi, General Masemola, and General Khumalo. Are you aware of it? You said you've heard of that allegation, but there is no truth to it. After this entire exercise we've gone through, do you still maintain that there is no truth or there is no basis to even believe such a narrative or an allegation?
Chair, I maintain that there was no, sorry, I don't have my file for the,
No, ask me. I'll
repeat the words.
the engagement at ad hoc.
Yes.
It's file 3, page 586.
Sorry, file 3.
After you say that is correct, then Mr. Ngola puts the question, there is an allegation. And then that's immediately followed by your response, and then you reference other criminal matters within the IDAC space. And you conclude, while we're at it, with the words, there is also no witch hunt against Lieutenant General Khumalo because there were no matters brought to IDAC prior to the referral by Mr. Adams. That's the... That's the part I'm reading. And I can very well perhaps appreciate the position you were in at the time you responded. Mine is slightly different. Do you still maintain the position after our 1.5 days of engaging with specifically decisions by IDAC targeting, no, wrong word, aimed at least two of these generals and the PKTT, can you still say the narrative is baseless?
Chair, the response I have is, at no stage did any of these cases start on the basis of wanting to target any individual, even those that I mentioned. We dealt with the investigations. In the course of these 2 days of engagements, and in the manner in which we have engaged, we would have to accept that we could have done things differently and or could have done things better. But that does not in itself make it a witch hunt or a target. They were not targeted at all. I accept that process is criticized. The manner in which things were done were criticized. I accept that criticism, Chair. And what I'm saying is that shortcoming does not make a targeting. It does not make it a witch hunt. It does not of itself say, we did it this way just to get to them. In the manner that these matters were presented, it is clear, and from the lengthy debates that poor Chair has had to have with me in getting us to understand our logic versus that logic, it is clear that we worked on what we had, interpreted the law as we have. There is a difference of opinion, and that difference of opinion, Council, highlights that things look the way they do and should have been done differently.
We dealt with your, one of the many Section 28 summonses.
Are you leaving this page?
No, I'm coming back to it.
Okay, thank you.
And at 3361 file 9, and we dealt with that quite extensively yesterday. I'm at 3363. Where, following Mr. Adams's complaint, in whatever terms it was expressed, you signed off on a summons that asked for a litany of documents that had no bearing on the complaint, including a list of all provincial heads and section heads who were stationed in Division Crime Intelligence, the performance assessment of all major generals for that year, the advertisement for that position, audio recordings and interviews. Then you want documentary records that General Jacobs refused to return. We have established that all those factors bear no relevance to the complaint. And I think we settled that yesterday.
We have.
Then you ask in the same summons for documentary files and applications for promotions and commanders and members of the political task teams through deviation. According to you, the PKTT did not feature anywhere. So once again, that is way beyond the scope of the original complaint by Mr. Adams. You recall?
I recall.
We then went to page 3531, which is annexure, you don't have to go there, annexure 397. That is the Section 28 summons signed by Advocate Manilao, which wanted the identities and certified travel documents of PKTT members who went to arrest Mr. Adams. And he does so under the cast number relating to the Mukwele appointment. You could not explain that Section 28, and I think we landed at a place where you said it ought not to have happened. Correct?
Correct.
In light of at least the three that I have named, logic dictates that it was a concerted effort to either discredit or somehow prejudice them. How can you sit there and you say the narrative is entirely wrong? And how do you suggest that it's just a difference of opinion? It's not. The facts, at least, are on the side of the narrative. What facts do you put forth to countenance that?
If you grant me an opportunity
Absolutely.
just to answer on why, because I had to ask the question, because I wasn't aware of this, Commissioner Baloy. I did ask Advocate Manila why this Section 28 went out. And I give you the explanation as follows. Part of the bail conditions in that matter was that the accused, which at the time would have included Lieutenant General Khumalo, were not to have any contact, interfere with, and or intimidate state witnesses, one of which was Adams. It is seen on television that there is a group of persons that have gone ahead to arrest Mr. Adams. That arrest has nothing to do with us. It is the police must carry on and do their work. There were reports that it is PKTT members who went to effect the arrest. It is now at this stage not a secret that the coordinator of the PKTT is Lieutenant General Khumalo. And the purpose behind it from the prosecutor was to determine whether someone else within the PKTT approved those trips. That is fine. And that if it was in fact General Khumalo who authorized those trips, then he was sending people to deal with Adams, and it could have a potential of interfering with the bail condition. It was asked on that basis. What subsequently happened is Mr. Adams appeared in court. The charges are read, and Mr. Adams has a way of how he expresses himself in public, and the prosecutors decided, the approval notwithstanding, can we just stand back and let them continue with their work? It was
Advocate Johnson, I want to say if that's the explanation he gave you, it's a false explanation. Those individual members and anyone else in the world was under no bail condition that they could not, that's one reason, that they could not deal with any witnesses. There was nothing like that. If indeed the issue was to determine whether General Khumalo breached a bail condition, it was simply, and I'm sure Advocate Manila knows that, you know that, it was simply a matter of asking General Khumalo, did you authorize an arrest of Mr. Adams? It's as simple as that. So if he gave you that explanation, it's false. He's not telling you the truth about why those questions, because that doesn't answer who went there, what are the names, give us the flight details. It doesn't answer the question whether there was a breach by General Khumalo of his bail condition. So no, I'm sorry, if you believe him, then something is wrong in this scheme of things. You should have, as soon as he said it, you should have seen it on his face, but that cannot be, it doesn't make sense. That you would go that way to try and determine that General Khumalo, whether or not General Khumalo has breached his bail condition. It's a false explanation.
So, 6 to 7. Midway, 6 to 7. Ms. James says, can we agree that you have a member employed in IDAC that has 2 cases and the one has not been finalized and IDAC is compromised? Your response is that if there are cases, they will be investigated. Now, if you run ahead in the same file to CJC 376, that is an article at 678. 678.
678.
678, yes. And this article, I think it's informed by comments by Pop Crew. First paragraph states that it was a startling revelation that IDAC appointed Sunil Belochan as a senior investigating officer, despite him having a warrant of arrest for alleged fraud. The second paragraph of that page then gives the detail of the docket from which the warrant of arrest comes from. We have a witness who has testified before the commission regarding the existence of this warrant. Okay. Ms. James at ad hoc brought your attention to the fact that there are cases pending against Mr. Belochan. And your parting shot was that the matters will be investigated. That's the one. We have a witness who appeared before the commission about 2 weeks ago, witness N. Witness N once again testified on complaints by, and I use the term liberally, the Pakistani community living, is it East London or PA, that which is said, East London, I think. It is alleged that investigator Belochan is extorting monies from and otherwise dealing with them harshly, and it's a very general summary. That's complaint number 2. The third we dealt with in this hearing, which is by Sergeant Ngosi of Mr. Belochan leading a team of 9 people, investigators and maybe others from IDAC of the 13th of July, 2026, to meet with him in the absence of his attorney and to solicit, again, it's my own summary, testimony from him that would implicate Generals Khumalo and Masemola. So these are 3 independent, these are 3 separate complaints. At least as regards the first, you undertook in November 2025 to the ad hoc committee that you will investigate. My question is, did you ever investigate that matter in particular? My second is, in your statement, your third statement, the statement of the 10th of July 2026, in response to a question posed to you through subpoena, no, through a regulation 10.6 notice. I'm at page 7 of that statement, paragraph 16. The question had been your relationship with General Khan and how well you know him. Your response was a fairly terse one, stating that you know that he's a general based at Crime Intelligence. Before you became the investigating director, March 2022, you engaged with him in meetings with other stakeholders and attended net joints or other subs meeting at which he was present, and to which you had been invited by relevant component heads, deputy national commissioner or divisional commissioner. So, according to your statement, you significantly played down that relationship. In the course of engagement, we have subsequently established that that relationship is actually deeper than as you describe at paragraph 16. And I think it was Commissioner Khumalo who informed you of testimony before this commission regarding the fact that you attended General Khan's 50th birthday, whenever that was, And I think that shed some light on this relationship, that besides a professional relationship, you have this personal one. As you are well aware, you may very well have heard, the Commission is in possession of General Khan's charts, downloads. And for that purpose, I would like to refer you to, I think it's file 9, annexure CJC 388.
Sorry, so which page? File 9?
File 9. The version I have starts at 1. Please bear with me, I'll find the page for you.
I think it's in file 8.
File 83194. Apologies. Up to page 3253. These are the chats between yourself and General Khan over a period. Just as a general note, would you agree that those chats reflect a deeper relationship than just being invited to a 50th birthday celebration by a colleague? You have a personal and deeper relationship with General Khan. Would you agree with that?
Yes, ma'am, I considered him a very good friend.
A very good friend. And in fact, on reading of this, it sounds like you visited each other's families?
No, we didn't.
You have been... I don't want to flight them.
Yes.
Personally, I don't.
Yeah, but I can indicate that there might have been an occasion where he would have invited us,
Yes.
but we have not, I have not gone to his home. He has not come to my home. We have not socialized.
What happened to the... you and General Khan had agreed that you, your family, together with your parrot, will visit General Khan, and you agreed what his family would cook for you for that day.
Yes,
So what, did that not come to pass?
it didn't come to pass.
But it's the kind of relationship where you have.
Where we would talk, yes. I have met him for lunch once or twice, but not at his home, not at my home. And the first time that I attended a social gathering, Chair, was at the 50th birthday, and both my husband and I had been invited, and we attended the birthday. But I have never been to his home, and nor he to my home.
I think I don't want to flight these. They don't take my point.
Can I suggest a way?
Read it to me.
Can you just look at 3245?
32?
3245. It might jog your memory. 3245, right at the bottom of the page. If you like, you can go to the next page. And as you answer the question.
that for me was, that was for me saying, I can't remember what we had been talking about, but that was for me in jest where I said, I'm bringing husband, daughter, and parrot to your home for supper tonight, start cooking. We didn't go to his home for, it's, if I could just use, it goes
in the
by
next
that.
page, go to the next page.
Yes. Yeah, he asked us what would we have liked to eat. I indicated what we like to eat. Yes, but we never went to his home. I'm dead serious, Commissioner. We did not go to his home. And we talked often like that about what's for supper, what you cooked. I'm coming over for supper, but you don't go over for supper. Sorry, Commissioner. Go ahead, Commissioner.
Are we still on home visits?
Oh, wait.
3249. Chat 7, and it continues all the way to 3251.
Mr. Lo, maybe while Advocate Johnson considers this, you should think about providing an explanation why you're not flighting this. We have flighted people's WhatsApp exchanges, and I think there has to be an explanation why.
There are a number of messages where they are communicating about minor children. And we've tried to do some deductions. In some places we end up with quite a lot of blacked out parts. And the purpose of my referring to the charts is to establish a very, very close relationship with between General Khan and Advocate Johnson. And if Advocate Johnson were to confirm to you that theirs is a very close relationship to a point that they greet each other by stating, saying words like, "Hi, gorgeous," then it makes my point without necessarily having to use the charts. So the charts are not going to give me any relevant evidence for anything except to establish this very close relationship, contrary to what she had stated originally in her statement. Thank you.
So, Advocate Johnson, if you just look at chat 5, 6, 7 on 3249, and then So, Advocate Johnson, if you just look at chat 5, 6, 7 on 3249, and then it continues to 32. That is a sign of people who have a close personal relationship. And you can see there that it's not an IDAC investigation. It's really two people who are friends, and this relates to a favor to him. It has nothing to do with IDAC's work. If you just look at 3249, I will just read, for example, where he wants to know who's plotting against him, and you are to assist him. And he suspects that it is the Hawks that are plotting against him, and the two of you decide to meet, and you arrange for him not to sign in the normal course, but to come in via the VIP entrance and come directly to your office without going via reception. I mean, that's a summary of it. I don't want to go into...
Yes.
That's what it shows, at least to me. And if I'm wrong, you can say you're reading it incorrectly.
So usually, just on a point of correction, usually when we do, and he's not an exception to the rule, when we do invite high-ranking police officers to the office, we usually let them use the the side entrance, and you will see even if you go now, if there's high-ranking police officials there at the head office, we grant them that entrance.
But you see here, the purpose of the visit was to come and see you on a personal matter.
And he did.
Yeah.
And it was a personal matter, and
Advocate Johnson, if I may, with your leave, if I may, I have argued against projecting these messages because they have a lot of personal material involving, children. And I now have a difficulty with your response to Commissioner Khumalo's question. What Commissioner Khumalo refers to is not how VIPs visit your office. He wasn't coming in his capacity as a VIP. He was coming in his personal capacity, requesting a favor from you regarding suspicions that he's being investigated by the Hawks and the like. And from that conversation, one picks up that the two of you are planning at some clandestine meeting. You end up, because of diary issues, you end up inviting him to your office. And then to avoid a record of the visit, you suggest he use that entrance. I beg of you, please don't make me do it.
No, I'm not disputing that he used the entrance. I'm telling you, ordinarily it was done. Here he did come to visit me. And unfortunately, when he did come to visit, it turned out it wasn't anything to do with the Hawks, but he had an issue about somebody plotting against him. It did turn out that it wasn't the Hawks. I want to make that clear. But it was...
The point is, this is not a VIP visiting IDAC office.
No, this was my friend.
This is a personal visit by a friend. And when you say to him, come via VIP entrance and don't sign in, you're not doing that for a VIP coming in his official capacity. You're doing it for your friend who's coming there to discuss personal issues.
I accept that, Chair.
And that is the whole point, to demonstrate that you have a very close relationship and the lengths you'll go to accommodate one another. I referenced how you address each other at times, either calling each other gorgeous, you tell each other how much you miss each other, and that's yes, dearest. Okay, now have we established the relationship? It's a very deep and personal one.
Yes.
And a very